Hi guys, welcome to the channel. Thank you for joining me. Thank you as always for your continued support. Well, the news I'm going to bring you today isn't the best news in the world, I have to be honest with you. It revolves around the court cases which are being looked at with regards to this green paper. Now, there are a number of people who are looking to put forward cases to make this green paper or the contents of it to see if it's illegal. And they've been getting some advice about these various court cases, and I'm going to read you an article where they talk about the outcomes. So let's have a look at it, and I'll talk you through it. Right, so this is from Benefits and Work website. No legal silver bullet to stop PIP proposals. The Benefits and Work and Inclusion London have obtained Council's advice on possible challenges to the Pathways to Work Green Paper proposals. The advice suggests that at this stage there appears to be no clear or obvious route for challenging or silver bullet regarding the flagship elements of the policy. Instead, individuals and organisations should focus efforts on challenging elements of the Green Paper politically as much as possible. So Benefits and Work and Inclusion London asked solicitors Lee Day, which is one of the ones that have been looking into it, to obtain advice from Council about the potential legal challenges to the March 2025 welfare reform proposals. Lee Day appointed barrister Tom Royston of Garden Court North Chambers to undertake the work. Both Lee Day and Tom Royston have a great deal of experience in social security law, and we are grateful to them for their very detailed advice that they have provided. The advice addressed in the following proposals in the Green Paper. Focusing PIP more on those with higher needs. The proposal to require at least one 4-point descriptor to be met to qualify for PIP. Scrapping the WCA. The proposal to amend the process by which ill and disabled people can claim income replacement benefit and the amount of money they will receive. The new unemployment insurance. The proposal to amalgamate contributory ESA and JSA into a single time-limited contributory benefit, and delaying access to UC health element until 22. That's not paying 18 to 21-year-olds PIP recipients any extra means-tested element in universal credit. Looking in summary at the above proposals, Council told us that substantial challenges to central aspects of the envisaged legislation would be likely to fall at various places along the spectrum from hopeless to challenging. In other words, given the information currently available, the chances of preventing the proposals being made law or overturning them subsequently appear to be limited. In relation specifically to PIP, a range of issues were considered, including, but not limited to, the decision not to consult on the measure, challenges under the Human Rights Act 1998, and challenges under the Equality Act 2010. But the probability of any challenge succeeding in relation to the PIP 4-point rule specifically was considered to be low and heavily dependent on circumstances. Council did stress, however, that there may well be successful legal challenges in the future to elements of the above proposals, but these are likely to be contingent aspects of the proposals which emerge along the way rather than to the elementary principles which are clear at the start. In other words, if the laws are enacted, then the courts may have a major role to play in examining the way they are interpreted and implemented, but not in upsetting the basic foundations such as the PIP 4-point rule. Benefits and Work will aim to support any such challenges in any way it can. We are not able to publish the advice at present, and we should add that it applies only to the 4 issues listed. The Green Paper contains many more proposals that were not covered. In addition, we did not ask for advice on whether the current Green Paper consultation is lawful, because our initial inquiries are primary about proposals which are not being consulted on. We know that this news will be greeted with considerable dismay by many readers who have hoped that the courts could prevent such early, cruel and discriminatory proposals coming into force. Sadly, there seems unlikely to be a silver bullet or a straightforward legal answer. And it goes on to say that the best way to do it is to put pressure on the MPs to vote against it, and also to vote against Labour whenever possible. And I think that is one of the best ways to do it. But it's a shame. It is a shame. I don't think it means that it's completely over. I think that there may well be ways that they can look at it in the future. I think that the pressure from Labour backbenchers and supporters of the supporters of not having the cuts in the first place, I think they will have a much bigger impact on this situation than the courts at the moment. But as it says, it's not that they can't take it to court, it's just that the actual outcome would be a poor outcome, so that it's unlikely to succeed. But in the future, it could well be that there are precedents set by the way it's implemented and things like that that will make it unlawful. So it's not the best news. I do appreciate that. But let me know down in the comments section what you think about this. I will leave a link to this article, of course, in the description. Please do let me know what you think. Please do subscribe if you've got this far, so to keep up to date with all the latest stuff that's going on. And I will see you next time.